When I tell you I will make you the smartest person in the room, that's going to include people that are at Yale Law School. That's right. Very interesting story out of the New York Times Magazine about history and tradition, with an argument essentially by a Yale-related professor that essentially tries to me, take issue with the notion of looking at history and tradition to understand the American Constitution. Let's break it down and let's talk about why there's some really funny things in here. You'll see why when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many books, including Disarm What the Ukraine War Teaches Americans About the Right to Bear Arms. Big news coming up very soon about the next book. Any day now, just waiting for the sign off from the publisher. You're going to like it. All right, folks. So, yes, I'm in a suit again. Busy Fox News time. A lot going on with the Trump world, protests around the country, First Amendment issues, and so on. So you're going to see me in a suit quite a bit, which is usually a really strong indication. I just had a national TV appearance, so I'll try to put links to it down below. You can also follow me on X at Four Boxes Diner, where I also put a lot of links to my appearances, whether it be on Newsmax, Fox News, or Fox Business, whatever. So make sure you check that out. All right, so today we're going to talk about this New York Times article. Very interesting, and I'm going to make you the smartest person in the room, which is my goal, because this article by a professor at Yale Law School, Emily Bazelon, I hope I pronounced that correctly, but Professor Bazelon at Yale teaches creative writing there. She has an article in the New York Times Magazine where she talks about history and tradition. The title of her article, and I'll put a link to it down below, is How History and Tradition Rulings Are Changing American Law. In it, she basically is trying to make the case, at least this is my takeaway from her article, that history and tradition is really kind of not really loving it. I don't get a sense she's a fan of this notion. But what's ironic is one of the ways she tries to prove the case that history and tradition is not really the way to go in interpreting the Constitution is she actually cites to the author of that case we all know as Roe v. Wade. That would be Harry Blackmun. Now, I should just note that what she tries to argue, and again, she does try to talk a little bit about the points back and forth, but she's pretty clearly not an originalist. She's pretty clearly not a conservative, as best I can tell. She seems really kind of bothered by the fact about, the Bruen case, obviously the Dobbs case that overturned Roe v. Wade. You'll see the article, see if you disagree with my take on this. Basically, she seems to be saying that history and tradition is not really a perfect solution to anything, and it's unfortunate they got rid of Roe v. Wade. Sort of the typical kind of views that you would expect out of these Ivy League institutions, which is kind of ironic since, I guess I come out of that world too, but I have a different take on a lot of the stuff, as you can probably guess. Okay, so here's what's interesting. One of the people she talks about is Supreme Court Justice Harry Blackmun. Now, Justice Blackmun is the author of Roe v. Wade. Now, what's quite interesting here is that Professor Bazelon here writes that Harry Blackmun was not an originalist and did not feel bound by the distant past. He treated history as a resource and not a command, according to professors that she's citing to in this article that you will see. What's most interesting, of course, is that's correct. History is not the command. The command in American law is the text of the Constitution, which is very good for Second Amendment supporters because the text of the Second Amendment says the right of the people to keep and bear arms shall not be infringed. It talks about a pre-existing right because if you look at the text, the right of the people to keep and bear arms shall not be infringed presupposes the existence of the right of the people to keep and bear arms. That's entirely consistent with the understanding. Now, the question then becomes, and this is the question that she's raising in her article, what exactly is the role of text? I should say, what is the role of history and tradition? Well, history and tradition is a guide to help us understand what the meaning of the words written down in a legal document are meant to or intended to mean or what they're intended to do. For example, if you and I enter into a contract today that I'm going to buy your car and pay you money, so on, so on, so on, and if there's a dispute, people go back to the document that we entered into, and then they say, what was the purpose of the document? What did you and I agree to? What did we intend at the time we entered into the contract. And it really doesn't matter 100 years from now what somebody else's interpretation of that contract means 100 years from now. The issue is what did you and I intend, and we figure out that intent not just by virtue of the words on the piece of paper, but perhaps by virtue of our actions or other things that lend credence to this. Now, the reason why I bring up this Harry Blackmun, author of Roe v. Wade, in the context of history and tradition is there's examples where Harry Blackmun himself used this exact history and tradition kind of approach to deciding constitutional questions, which is exactly what the U.S. Supreme Court did, for example, in Bruen, where they took the text of the Second Amendment, they said this is the command, and then they looked to history to kind of corroborate and discuss what may or may not be within it, things along those lines. But that is not unusual, and we even see left-wing judges doing the same. Again, the author of Roe v. Wade, Harry Blackmun, did exactly this when he signed off to the majority opinion in a case called Marsh versus Chambers, which dealt with a legislative prayer in the Nebraska legislature and whether or not that prayer at the start of the legislative session every day violated the First Amendment. Specifically, the First Amendment's clause that says, the government shall not establish a religion or shall not establish some sort of religious practice along those lines. And the Supreme Court decided that a state legislature bringing in a chaplain to pray over the session was not a violation of the First Amendment's establishment of religion clause. Now, the reason why I bring this up is the rationale and the reasoning from this 1983 decision by the Supreme Court, which the author of Roe v. Wade, Harry Blackmun, was in the majority on. Tell me if some of the language I'm going to read here from this decision of Marsh versus Chambers sounds familiar to you. For those of you who've been tracking the Second Amendment litigations and some of the Second Amendment teaching that I've been giving you here based on Supreme Court precedent, see if it sounds a little bit familiar. Let's turn to the record and see what Justice Blackmun, the author of Roe, signed off on when he signed off on the majority opinion. He didn't write the opinion, but he was in the majority that signed off on the following. Check it out. The opening of sessions of legislative and other deliberative public bodies with prayer is deeply embedded in the history and tradition of this country. From colonial times through the founding of the Republic and ever since, the practice of legislative prayer has coexisted with the principles of disestablishment and religious freedom. In the very courtrooms in which the United States District Judge and later 3 circuit judges heard and decided this case, the proceedings opened with an announcement that concluded, "God save the United States and this honorable court." The same invocation occurs in all sessions of this court, the U.S. Supreme Court. Wow. Hear what I just said? Do you see what that just said? Here you have Justice Blackmun in the majority in Marsh versus Chambers in 1983, literally saying, talking about deeply embedded in the history and tradition of this country. Why was he talking about this? To interpret the Bill of Rights, specifically the First Amendment. So the question becomes is, if Harry Blackmun, the author of Roe, is comfortable using text and tradition to interpret the meaning of the First Amendment in the Bill of Rights, why shouldn't the Second Amendment world feel comfortable using text, history, and tradition, which we actually talk about? It's actually text and historical tradition, but set that issue aside for this video. The reality is, using history and tradition to understand the meaning of the Bill of Rights is right down the middle. This is what every judge is supposed to do, because remember, go back to my example of the contract. You want to understand what the people who entered into the contract meant. And you look at the words they used, which is the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed. That's the ultimate command, the ultimate evidence, the ultimate historical proof of what the Founding Fathers intended. But to the extent there's questions about the scope or maybe restrictions that might be allowed, you're allowed to indeed look to some history, which is what the Supreme Court says, that if there's a long-standing, well-represented, well-established historical tradition of firearms regulation, which the government bears the burden to show, by the way, then maybe there could be a restriction on the scope of the right of the people to keep and bear arms. And the example I like to give you is, if there obviously was no right to commit cold-blooded murder in the Bill of Rights. So even though it says the right of the people to keep and bear arms shall not be infringed, that does not give you a constitutional right to go out and commit cold-blooded murder with an arm. Why do we know that? It's not in the text of the Constitution, but we know that by virtue of the longstanding historical tradition of exactly that, that murder with arms is not permitted in American law, despite what the Second Amendment, despite the text of the Second Amendment. And again, you can see here in Marsh versus Chambers, this reference to history and tradition, and that's literally kind of the opening of the opinion. But let's look at the other examples that, by the way, this discussion of Marsh versus Chambers does not appear in this New York Times article about how history and tradition rulings are changing American law, because it's really not new, because even back in the 1980s, the American courts, including the author of Roe v. Wade, Harry Blackmun, was using history and tradition to decide cases involving the Bill of Rights. Let's take another look from this decision in Marsh versus Chambers and tell me if it sounds familiar in the context of the Second Amendment, although this is a First Amendment case. Clearly, the men who wrote the First Amendment religion clause did not view paid legislative chaplains and opening prayers as a violation of that amendment, for the practice of opening sessions with prayer has continued without interruption ever since that early session of Congress. It has been followed consistently in most of the states, including Nebraska, where the institution of opening legislative sessions with prayer was adopted even before the state attained statehood. Wow, very powerful language. And again, here's an example of the Supreme Court in 1983. Did you hear what I just said? 1983. Justice Scalia was not even on the Supreme Court. That's how far back this goes. Justice Thomas was not on the Supreme Court. This is the 1980s that we're talking about. And yet the Supreme Court is using history and tradition, historical traditions, to understand the scope and the meaning of, for example, the First Amendment. But let's go on and let's see if this is very important. I'm going to do an independent video about this, the importance of the First and the Second Congress. That, remember, the initial Constitution did not have the Bill of Rights. Remember, the initial Constitution itself, when it was enacted, did not have a Bill of Rights. The Bill of Rights is written by the first Congress. It's then adapted. It's ratified, and so on and so on. So again, why is that important? Because historically, the U.S. Supreme Court puts a lot of weight on the understanding of the First and really the Second Congress as to what the Constitution means, because they were the ones that wrote the Bill of Rights. And the argument goes, well, they would not be doing stuff in that First Congress or Second Congress that would violate the Bill of Rights as a general matter, because they are the ones that understood what the Bill of Rights meant. And that is exactly what's discussed in this case of Marsh versus Chambers, which again included the author of Roe v. Wade, Harry Blackmun. The reason why I keep bringing up Harry Blackmun is he's the quintessential great liberal justice who gave the left Roe v. Wade, and yet here you have Harry Blackmun using history and tradition to interpret the Bill of Rights, to show that you understand that even the left uses history and tradition. Of course, when they don't like the results, they'll just deviate from it, but they recognize this as an appropriate a way to interpret the Bill of Rights. But let's see what Justice Blackmun signed off on in Marsh versus Chambers, yet again, just to show you the importance of history and tradition and our founding generation when it comes to interpreting the Bill of Rights. Standing alone, historical patterns cannot justify contemporary violations of constitutional guarantees, but there is far more here than simply historical patterns. In this context, historical evidence sheds light not only on what the draftsmen intended the Establishment Clause to mean, but also on how they thought that clause applied to the practice authorized by the first Congress. Their actions reveal their intent. Specifically, an act, quote, passed by the first Congress assembled under the Constitution, many of whose members had taken part in framing that instrument, is contemporaneous and weighty evidence of its true meaning. Did you hear what I just said there? Critically important, folks, that the first Congress is so important in terms of what the Second Amendment and the Bill of Rights means that it's given extra weight by the U.S. Supreme Court. But let us carry on as they talk about this Establishment Clause, which again is part of the Bill of Rights. No more is Nebraska's practice of over a century consistent with 2 centuries of national practice to be cast aside. It hardly can be thought that in the same week, members of the first Congress voted to appoint and to pay a chaplain for each house, and also voted to approve the draft of the First Amendment for submission to the states. They intended the Establishment Clause of the amendment to forbid what they had just declared acceptable. Now that's extremely important. You hear what I just said there? Here you have not a conservative court in any respect in Marsh versus Chambers in 1983, saying that when you look to the understanding of their Bill of Rights, you look very carefully at what the men who actually wrote the Bill of Rights intended. Now, why is this very important for the Second Amendment? It's very important for many reasons, but in one particular reason why I want to bring to your attention. Remember how I've talked to you repeatedly that the Second Amendment was adopted with the Bill of Rights in 1791. 1791. What happened in 1792? The first Congress after the adoption of the Bill of Rights. What happened in 1792 that's important to our rights? That's the adoption of the Militia Act of 1792, which said that all 18 to 45-year-old white free men were part of the militia and had to bring their own privately owned firearms and ammunition with them to militia musters. You see that? So this is going to be very powerful evidence. We've always talked about the Militia Act of 1792, but in light of this language from, for example, Harry Blackmun, the liberal, the 1792 Militia Act is particularly important because it was adopted by the same men that wrote and ratified and blessed the Bill of Rights, which included the Second Amendment. So the point being, the same people that wrote the Second Amendment also wrote the Militia Act of 1792 that said 18 to 45-year-old men were part of the militia and had to bring their own firearms. So to the extent the anti-gunners want to say, for example, 18, 19, and 20-year-old Americans today have no right to keep and bear arms, well, guess what? You go back to 1791 and 1792 and realize that the same men that wrote the Second Amendment were the same men that said 18, 19, and 20-year-olds and then some had to bring their own firearms and own ammunition and own weaponry within the militia muster, which means obviously they thought that 18, 19, and 20-year-olds had the right to keep and bear arms, because how can you have if you don't have the right to keep and bear arms and the right to acquire guns at the age of 18, 19, and 20, how can you show up for militia duty in 1792 if you're not able to get the arms that you're required by the same Congress that adopted the Second Amendment to show up with these weapons, right? So that's the kind of thing we're going to see the Supreme Court. And the truth is, you're going to have a Supreme Court today essentially embracing the approach to the Second Amendment that was used in the context of the First Amendment all the way back in 1983 by left-wing judges, including Harry Blackmun, the author of Roe v. Wade, in cases such as Marsh versus Chambers. So there you have it. Take a look at this article by Emily Bazelon from Yale about history and tradition, and then compare it to Marsh versus Chambers, which she doesn't discuss the language and the ruling of Marsh versus Chambers in our article, but I think that would have been a very valuable thing to have added to this article in terms of how history and tradition is not used just by conservatives. It can be used by the left as well, including the author of Roe v. Wade. So there you have it. All right, folks, so hope you learned something here today at the Four Boxes Diner. Don't forget to follow me on X at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.